the targeted retention of traffic and location data, which is limited on the basis of objective and non-discriminatory factors, according to the categories of persons concerned, or using a geographical criterion for a period that is limited in time to what is strictly necessary, but which may be extended. The general and indiscriminate retention of IP addresses assigned to the source of an internet connection for a period that is limited in time to what is strictly necessary. The general and indiscriminate retention of data relating to the civil identity of users of electronic communication systems, and recourse to an instruction requiring providers of electronic communication services by means of a decision of the competent authority that is subject to effective judicial review to undertake for a specified period of time the expedited retention of traffic and location data in the possession of those service providers, provided that those measures ensure by means of clear and precise rules that the retention of data at issue is subject to compliance with the applicable substantive and procedural conditions, and that the persons concerned have effective safeguards against the risks of abuse. 2. Article 15.1 of Directive 2002/58 as amended, read in the light of Articles 7, 8, 11 and 52.1 of the Charter of Fundamental Rights, must be interpreted as precluding national legislation pursuant to which the centralized processing of requests for access to data, which have been retained by providers of electronic communication services issued by the police in the context of the investigation or prosecution of serious criminal offences, is the responsibility of a police officer who is assisted by a unit established within the police service which has a degree of autonomy in the exercise of its duties, and whose decisions may subsequently be subject to judicial review. 3. EU law must be interpreted as precluding a national court from limiting the temporal effects of a declaration of invalidity, which it is bound to make under national law with respect to national legislation imposing on providers of electronic communication services the general and indiscriminate retention of traffic and location data, owing to the incompatibility of that legislation with Article 15.1 of Directive 2002/58 as amended, read in the light of the Charter of Fundamental Rights. The admissibility of evidence obtained by means of such retention is, in accordance with the principle of procedural autonomy of the Member States, a matter for national law, subject to compliance inter alia with the principles of equivalence and effectiveness.